What are 3 myths in Illinois dog bite cases? Hi, I'm Josh Rohrscheib. I'm a personal injury lawyer in Central Illinois, and in this video I'd like to refute 3 commonly believed myths in Illinois dog bite cases. Okay, myth 1, dogs get 1 free bite. So what does this mean? In several states there's a rule of law called the 1 bite rule, and that law basically says that for an injury victim to succeed in bringing a dog bite claim in those states, they have to be able to prove that the dog's owner knew the dog was dangerous or aggressive. Typically, that's shown by proving that the dog bit someone previously and the dog's owner was aware of that. Hence the 1 bite rule. The thing that's important to know in Illinois, there is no 1 bite rule. The 1 bite rule does not apply under Illinois law. Instead, in Illinois, you have something called the Illinois Animal Control Act. And under that act, a dog bite victim can recover for their damages, even if it's the only time the dog has ever been aggressive to anyone. So it is a myth that dogs in Illinois get 1 free bite. Okay, myth 2. Myth 2 is that the dog owner's insurance company will take care of your medical bills. And unfortunately, this is a myth. Typically in these cases, we look to recover from a homeowner's insurance policy or a renter's insurance policy, sometimes a personal umbrella policy. And dog bite victims are often led to believe that the insurance company is going to take care of everything for them, that they're going to pay their bills as they come due. And that, unfortunately, is almost never the case. The insurance company uses their failure to pay your medical bills as they come due as a tactic. And let me explain what this means. If a person is injured in an accident or a dog bite or really almost any kind of injury claim, almost all of them work the same way. The insurance company that's ultimately going to be responsible for this claim, they know that the person may be hurting, they may have medical bills coming in, they may be missing work, they may be getting calls from the collection agency, and they may be feeling some pressure. They may have some financial pressure related to all of these bills. And the insurance company's goal is to settle cases for the least amount possible. And they know that collection calls and unpaid bills and notices coming in month after month can apply some pressure to injury victims. So they typically will not pay your medical bills unless and until you sign a release settling your case with them. And their refusal to pay your medical bills is simply a tactic to try to apply pressure to get you to accept a lower settlement than you should take. So it's a myth that insurance companies will just pay your medical bills as they come in. Instead, what you should do is get help from a lawyer who can help you understand what the value of your case actually is based on their experience, based on jury verdict and settlement reports in similar cases. And that lawyer can help you attempt to negotiate a fair value for your case so that if you settle the case with the insurance company, you'll have some confidence that you're being treated fairly. Your lawyer can also negotiate reductions for you in those unpaid medical bills in most cases. In some cases, there are very strong tools lawyers can use to negotiate huge savings for you in your medical bills. But it's unfortunate that it's a myth to think that the insurance company will just do right by you, pay all your bills as they come in. Okay, the third myth is that you have to sue the dog's owner to recover for your damages in an Illinois dog bite case. Unfortunately, a lot of folks think that the only way to recover a fair value for their claim is to file a lawsuit, maybe even go all the way to a trial against the owner of the dog that bit them. And in Illinois, that's a myth. And the reason is, Illinois has a very favorable law for dog bite injury victims called the Animal Control Act. And the law is so favorable to injury victims that in a whole lot of these cases, the insurance company knows that if this is litigated, they're just going to lose. And it doesn't necessarily make sense for them to pay $20,000, $30,000, $50,000 to defense lawyers to litigate a case for years just to lose it. So we often find in dog bite cases, more than other types of cases, insurance companies are more motivated to try to settle cases early on. And it's important to keep in mind there are usually 2 kind of phases in the way we handle these actions. So the first is an insurance claim. And that's what it sounds like. We open a claim with the insurance company and we try to negotiate with them. We assemble all the materials we can to make our client's case to them in the strongest way possible. And we try to negotiate a good settlement for our client. And if we can negotiate a settlement at the claims level, the case would be done and you don't have to sue anyone. It's only those cases that can't be settled at the claims level where there's ever a need to file a lawsuit. And often, if you do have to file a lawsuit, negotiations can continue, and sometimes cases are settled shortly after a lawsuit is filed. And keeping in mind that the dog bite cases, in a lot of situations, involve dog owners who happen to be friends, neighbors, family members, loved ones. If you absolutely have to litigate, it can be done in a way, in most situations, where it doesn't have to really harm or destroy any of the relationships involved to get you justice. In a lot of these situations, your family member, your neighbor can be made to understand that this is really just being litigated because their insurance company isn't treating you fairly. So, hey, I hope that this explanation of these 3 commonly held myths and why they're myths, I hope this is helpful. If you have any other questions about dog bite claims, I'd be happy to offer you a free consultation to talk about your situation. And I appreciate you taking the time to watch this video.